Your Honor, you will not find anywhere in the pages of history, nowhere, any suggestion that the traditional definition of marriage across cultures, across time, had anything to do with homosexuality. Had nothing to do with it.
You heard Mr. Olson this morning recount the background of the Loving decision by the Supreme Court in 1967. And up to that time, numerous states had laws on the books which prohibited interracial marriage. You recall the rationale that was used by the courts was that the mixing of the races would have serious corrosive effects on society.
Your Honor, those racist sentiments and policies had no foundation in the historical purpose of marriage. And in fact, they actually made people have illegitimate children, illegitimate natural children, which again was, as the Eighth Circuit said, only opposite-sex couples can procreate naturally, and therefore...
You don't draw any distinction between the state's interest where an opposite-sex couple have had to require some form of intervention in order to produce children.
Your Honor, they're not quite the same, no.
Well, then what's the difference?
I think the state's main concern in regulating marriage and seeking to channel naturally procreative sexual conduct into stable and enduring unions is to minimize what I would call irresponsible procreation.
What?
That's not a good term. I can't think of a more serviceable one. And that is procreation that isn't bound by social norms and often leads to children being raised by one parent or another, or sometimes neither parent.
But my point was that there are a number of heterosexual couples who do not naturally procreate, who require the intervention of some third party or some medical assistance of some kind. Why don't those same values you've described apply to lesbian couples and gay couples? Coming together, supporting one another, providing love, comfort, and support for one another. Why don't all those considerations apply just as much to the plaintiffs here as they apply to John and Jane Doe?
Your Honor, I want to conclude this piece of my argument by calling the court's attention to a case in which the 11th Circuit upheld a Florida statute that prohibited gay adoptions. Taking all this information into account, the legislature could rationally conclude that a family environment with married opposite-sex parents remains the optimal social structure in which to bear children. And that the raising of children by same-sex couples presents an alternative structure for child rearing that has not yet proved itself to be as optimal as the biologically based marriage norm.
I want to ask you something. Why should Mr. Blankenhorn's testimony be admitted? Does he meet the Daubert standards?
His professional life for 20 years has been devoted to the study of marriage. He's written 2 books on the subject matter.
Were they peer-reviewed?
I think the Ninth Circuit standards for qualifying an expert are particularly liberal. So, Your Honor, again, I didn't really come here particularly to re-argue that, but I do believe... All right. Would the court entertain, well, a break? Maybe 5 minutes?
Why don't we take a little more than that? Resume in 10 minutes after the hour.
What did that mean?
What?
Irresponsible